Good morning, everybody.
This is the speaker. This one is a speaker.
Sorry for the little technical hassle. Let me start all over again. So, good morning, everyone. Before I begin this session and deliberate on the subject chosen for today's webinar, let me take a fraction of your time to introduce myself. I'm Advocate Saumya Sharma, and I work as an associate with Abhay, Nevagi and Associates, and I'm based out of its Pune office. So besides attending to the various matters in the court, I have been actively working with other team members in providing legal counseling to our clients in instances of sexual harassment and family matters. Dear listeners, our today's session is dedicated to anti-sexual harassment laws in India, or if I were to give it a detailed connotation, laws addressing the issue of sexual harassment with a special focus on sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act 2013. Well, as the title suggests, the statute is specially enacted by the Parliament of India to deal with the instances of sexual harassment of women at workplace. So for the purpose of this webinar and for a convenience reference, let's call this particular law with an exceptionally lengthy title as Act. Dear listeners, as I started gathering my thoughts on the topic, I was instantly recalled of a Bombay High Court order pronounced very recently in the month of April this year. So in this particular case, a female employee had received 2 emails from her editor, also a colleague at work. So apparently the emails contained abusive language. If I am to understand, the emails were probably an aggressive gesture towards the female as she had failed to attend a particular office party. Offended by the emails, she first approached the HR and then the upper management, who kept assuring her that her complaint will be addressed. However, after no action was taken at internal level, she subsequently approached the National Commission for Women and, upon Commission's recommendation, lodged an FIR with the police. When this particular person against whom the FIR was lodged approached the Bombay High Court to get the FIR quashed, it was outrightly denied by the High Court. While this instance highlights the lackadaisical attitude of an organization to probe in a matter which otherwise could have been resolved without intervention of the court, there's another instance which reflects the hindsight of the issue. Dear listeners, on 11th April, another High Court in India set aside the inquiry report of the Air India ICC. Now, ICC refers to Internal Complaints Committee, and I'll explain about this a little later. Now, dear listeners, this particular ICC report had found an employee guilty of harassing women workers at workplace. However, the report was set aside by the court, and the court also directed the committee to reconsider the matter and allow the employee to present his side of the story. Now, this person against whom these charges were levied had made a petition before the court, as according to him, the charges were fabricated. He said that the Internal Complaints Committee had not heard his version, neither had he was given the opportunity to cross-examine the complainants. The court observed that there was a sheer violation of the principles of natural justice, as per which everyone must get an opportunity for being heard. In the same matter, the state government also submitted that an investigation by the crime branch had revealed that these allegations against this particular officer, that he had harassed 17 female employees at work, were all false. It was later revealed that the complaint was fabricated by a group of employees with an intent to oust this particular officer from his office. Upon probing the matter even further, the crime branch also found out that except for one, the remaining signatures existing on the complaint were all forged. Dear listeners, this tempts us to consciously think, one, what protection does the law afford to women in cases of sexual harassment at workplace? And second, what are the bounds within which this particular law operates? Dear listeners, our subject of this webinar sounds relatively easy. However, the pace at which we are witnessing the developments and judicial approach towards this law, we find that with the passage of time, the law is unfurling in its various dimensions. Listeners, in order to understand the latest developments, we must first understand certain key aspects of the law, such as the background of this particular law, its objectives, the coverage, as to whom the law is actually meant for, and of course, the compliances mentioned under this particular law. Dear listeners, as a country, we take extreme pride in the fact that we are governed by rule of law, which essentially means that no one is above law. It's because of this principle, it's possible for every aggrieved person to seek justice before the judicial system. Our constitution also spells out the fundamental rights and socialistic aspirations of our immensely diversified and pluralistic society. Dear listeners, we must understand that every woman, irrespective of her caste, creed, background, or stature in the society, has a perpetual and inherent right to live with dignity and protect herself from violence. The laws and the cluster of the laws meant for protection of women are simply means to get these rights acknowledged. It's also important to note that all of these rights flowing out of women laws have been enacted to create an enabling and safe environment for women in a pervasive manner in different realms of life. However, because of lack of implementation of these laws, a major impediment happens in achieving these particular goals. Therefore, it's extremely important not only to create awareness amongst the women folk, but also to sensitize men towards the fairer gender. So, listeners, coming back to the main topic, the discussion on sexual harassment will be completely incomplete without the reference of a supremely important case, Vishakha versus State of Rajasthan. Dear listeners, this case was instrumental in laying down rules and guidelines to protect women from sexual harassment at their workplaces, which now we commonly known as Vishakha guidelines. The Sexual Harassment Act itself is based on these guidelines. It arose out of a case of brutal gang rape of a publicly employed social worker in one of the villages in Rajasthan. This particular female was gang raped by a group of Thakurs when she had tried to stop a child marriage in that village. When the matter went up to the trial court acquitted the accused, but the female did not lose hope. She wanted to continue the fight and the injustice she had faced. In the meanwhile, this also inspired women groups and other NGOs to join her, and they all collectively ended up filing a petition in the Supreme Court under the name Vishakha and demanded protection of from sexual harassment at the workplace. This finally gave birth to the Vishakha guidelines, and then recently to the Sexual Harassment Act 2013 is obviously a consequence of those guidelines. Dear listeners, let's begin our discussion on the specifics of the law. So, before understanding a law, it's important to know the objectives of the law. In case of this particular law, the central idea behind this act is to provide an environment free of gender based discrimination. The listeners, in the past few decades, there has been a tremendous growth in women workforce, and the necessity of having congenial work environment becomes all the more important. Now, we can't completely eliminate the eventualities of instances of sexual harassment. And for this reason, the another important object laid down under the Act is to create a permanent mechanism, lay down standards by which the instances of sexual harassment can be addressed in a timely fashion, in a time bound manner. Last but not the least, that also aims to create awareness about sexual harassment and its various forms so that the community at large deters from being involved in such acts. Dear listeners, let's move on to another key question involved in the discussion of this act. And let me take you to a yet important definition under the act. What amounts or what place would we like to call as a workplace in terms of this particular act? Dear listeners, as per the definition given under this act, a workplace can be any department, organization, undertaking, establishment, enterprise, institute, office, branch, or a unit of an establishment which is owned completely or partially by the government. So, in short, to say all the public units can be called as workplace. Also, any private sector organization or a private venture undertaking enterprise institution, including those institutions carrying out commercial, professional, vocational, or even educational activities are a part of workforce. Hospitals and nursing homes are workplaces. Any sports institute, stadium, sports complex is also a workplace. And any place visited by the employee arising out of the course of employment also includes a workplace. So it can be safely concluded that nearly all organizations that we can practically think of are covered under the Act and are would be called as workplaces in terms of the Act. Now, another important question, what do we know and how do we know that a particular act is an act of sexual harassment? Or in other words, how sexual harassment is defined under this law? Dear listeners, sexual harassment, strictly in terms of the law, can be a physical contact, a demand or request for sexual favors, an act which involves showing pornography or any other physical or non-verbal conduct of sexual nature, or it can also be sexually colored remarks. However, it's important to understand that the points I just stated are not strictly objective in nature. In fact, there cannot be a set acts or a set of acts that we can safely say that would amount to sexual harassment. However, whether an act amounts or it does not amount to sexual harassment is to be determined on a case to case basis. Let me quote a few instances before you and help you to understand what sexual harassment can be or cannot be. For example, at a particular instance, boss tells a female employee that he could give a promotion if she went out for dinner with him. Now, this can be taken otherwise by the female employee or it cannot be simply liked by the female employee. To quote another example, let's just say at an office party, one colleague bumps into another. So the male colleagues ask the female colleague, approaches her, and grabs her arm and tells her to dance with him. This may or may not be taken positively by the female employee and can amount to sexual harassment. Dear listeners, I can safely say that whether an act will amount to sexual harassment or not cannot be strictly defined. The act has laid down certain guidelines or certain parameters on which you can judge a particular act. However, to safely analyze whether an act amounts to sexual harassment or not is to be judged in the background of the circumstances surrounding the particular act. Your listeners, now we have come to another important aspect laid down under this act, which is Constitution of Internal Complaints Committee, which I briefly mentioned earlier in the webinar, and the Local Complaints Committee. Dear listeners, the Act prescribes that an Internal Complaints Committee, or as shortly known as ICC, has to be set up at every office and branch of an organization, and such organization which has minimum 10 employees. So every organization which has 10 or more employees is required to establish and constitute an ICC at an internal level. The Act has also laid down that the government is also required to set up a local complaints committee at a district level to investigate the complaints regarding sexual harassment from establishments where the ICC has not been constituted. Moving ahead, according to this act, the Internal Complaint Committee, as I said, is required to be constituted at every organization which has more than 10 employees. The failure on the part of an employer to not comply with the provisions of the act or not to constitute an internal complaints committee is punishable under the law with fine up to 50,000 rupees. Dear listeners, we have reached the end of this session, and in our next session, we'll be speaking at length about the role of HR in handling a complaint of sexual harassment at an organization, the procedure of filing a complaint, and what actions are to be taken by the ICC once the complaint is filed, various roles and responsibilities of the ICC while handling a complaint, how should an inquiry be conducted in a case of a sexual harassment complaint, and important social legal aspects which the ICC must be aware of. I sincerely hope that our listeners will find the information divulged during this session useful. We at Abhay Nevagi and Associates aspire to extend our support to the ones in need. Thank you so much for listening. Our knowledge sharing mission will continue and we'll conduct many more such sessions in the coming future. Thank you again.